Welcome, everyone. Thank you so much for joining us today. I'd like to thank you on behalf of the Birnbaum Women's Leadership Network, the Law Alumni Association, and the Law Alumni of Color Association at NYU School of Law. We're so thrilled to bring together this incredible group of panelists for our panel on Free Britney, the Dynamics of Sex, Money, and Power. The Birnbaum Women's Leadership Network at NYU School of Law provides innovative leadership training and highlights gender inequities in the legal profession and beyond through conversations like these. So today we're thrilled to welcome all of these incredible panelists. A few logistics: we will have time for questions, so please submit your questions via the Q&A box on the bottom of your screen and we'll get to as many as we can. Automated captioning is available for this event, so if you wish to access the captions, please click the closed captioning button. So to get things started and leave as much time for this wonderful discussion as possible, I'm so pleased to introduce our moderator, Professor Alexis Hoag of Brooklyn Law School. Her scholarship and teaching focus on alleviating racial subordination in the criminal legal system and carceral abolition. Professor Hoag is a 2008 NYU law grad, and we're so pleased to call her an alum. And with that, I'll turn it over to her to introduce our panelists. Thank you.
Great, thank you so much, Abby. And thank you to all the entities at NYU that brought us together, the Birnbaum Women's Network, the Law Alumni Community, and the Law Alumni of Color Association. It is such a privilege to be back virtually with NYU for our program today. I'd like to turn briefly to our panelists, and I'll introduce each of them, provide some framing questions for our discussion, some framing points, and then I'll open it up with a question for all of our panelists. If you do have questions and inquiries throughout, please put them in the Q&A box. I'll keep the discussion going, but I'd love to hear from our attendees. So with that, I am happy to introduce our first panelist, Adam Cohen. He's a lawyer, an author, and a journalist. His most recent books include Supreme Inequity, the Supreme Court's 50-year battle for a more unjust America, and Imbeciles, the Supreme Court, American Eugenics, and the Sterilization of Carrie Buck. I'd also like to welcome Professor Jasmine Harris, newly of the University of Pennsylvania Law School, recently at UC Davis School of Law. She is a leading expert on disability law, anti-discrimination, and evidence, and I encourage all of you to check out her recent work in the Yale Law Journal, Reckoning with Race and Disability. I'd also like to welcome Ria Tabaka-Mar. This is probably the least important thing about her bio, but she was my classmate in the class of 2008 at NYU Law. Currently, she's the director of the ACLU Women's Rights Project, where she oversees women's rights litigation and is a leading voice on gender issues. I'd also like to welcome Professor Melissa Murray of our very own NYU School of Law. She is a leading expert in family law, constitutional law, and reproductive rights and justice. And you can hear all of our panelists on several media outlets. So it is a real privilege for us to have them all together on these issues. So conservatorship. For many of us outside of the disability rights context, this is a relatively new term and idea. It essentially allows a court to designate usually a family member, some sort of government official, or some other third party to take over a person's financial and medical decision-making. And over 1 million adults in this country are subject to some sort of conservatorship or guardianship relationship. And there is a disproportionately large number of marginalized people that are subject to these relationships. And I'm speaking specifically of women with disabilities and also Black people with disabilities. And so Britney Spears, where does she fit into this? In 2008, many of us witnessed televised that the police placed her in a temporary involuntary mental health hold. And they used a mechanism through California law, the Latterman-Prentice-Short Act, which covers people with grave disability. And generally that's a temporary hold. The court later moved her into something that can be more indefinite, and it was a probate conservatorship, which is what she is under now. So it's now been 13 years for Britney Spears. We heard recently in June testimony that revealed a person who was denied legal counsel of choice, subjected to forced contraception, mental health treatment, and forced to perform and labor against her will. This case, Britney Spears, the issues that her plight really raises, explore issues of individual rights, disability, gender, among others. And I'd like to open it up to all of our panelists. What was your initial reaction? What did you think about when you heard or perhaps read Britney Spears' testimony in June, raising these issues and concerns?
I'm happy to go first. I think one of the things I thought was really interesting about Britney Spears' situation was how commonplace it actually is. I think what was surprising to everyone is that it was happening to someone like Britney Spears, who is a household name. But as you've mentioned, Alexis, conservatorships and guardianships are incredibly common, certainly for those with disabilities. And again, disability is a socially constructed category. And so who falls into that category is also socially constructed. And, if we think longitudinally about this, there are a number of people who have been denominated as disabled, and we might not consider them disabled by our understandings of that term today. And so this has often been a way to label people such that we can then, whether it's through the state or through other entities, exert control over them in particular ways. And this has happened, and we can talk about it over time in lots of different contexts. The other context that you didn't mention, where conservatorship and guardianship does come up quite frequently, is with elder care. And that is a minority group that we all will be a part of at some point in our lives, if we're lucky enough to have a long life. And it's incredibly common in those circumstances, whether the elderly or aged have mental incapacities or physical incapacities, they are often subject to situations where there is a guardian, whether it's someone they've denominated themselves or someone who's appointed by a court. And often some of these court-appointed guardians are actually paid by the state. So it is a kind of revenue-generating enterprise in some respects as well.
Thank you. Other initial reactions to Britney's testimony? Professor Harris.
Well, I have to say that I had the disability rights hat on, and so I said, yes, I'm not surprised, because this has been a disability rights issue from the onset. And as Professor Murray says, this is something over time. Who falls into the group of people with disabilities changes over time, but not the nature of legal capacity and how legal capacity is understood as an on-off switch in something that is all or nothing. That is to say, most people with disabilities who fall under conservatorship or guardianship, those two can be used interchangeably depending on the state. It's just different names. That system is a way historically to strip rights almost holistically, right, in a plenary form from people. And people with disabilities are subject to it. Most often people who are older adults, etc. But I was certainly I was not surprised. I am pleased at the discourse that's happening, but certainly no surprise.
Adam, if you can unmute yourself.
Thank you. I would say that I had a sense of horrified deja vu, and that's because, as you mentioned in the introduction, I wrote a book called Imbeciles about a 1927 Supreme Court case, Buck versus Bell. And that was a case where there was a poor Southern woman, much like in some ways Britney Spears, who of course became wealthy, but started out quite poor, is not well educated, has had a very sheltered life. Carrie Buck, there was nothing wrong with her, but she was judged to be feeble-minded. And as a result, the state of Virginia wanted to sterilize her under eugenic sterilization law. The Supreme Court 8-1 upheld Virginia's right to do it, and they did sterilize her. So I'm looking at almost a century later, a very similar story of this woman who wants to have children. She talked about that in the remarks that you mentioned. The state is helping to stop her from having children. I think the most shocking part of this whole story is that she's forced to have an IUD, and that this is still going on, and it's so wrong. One thing I'm encouraged by, though, is she got to speak. Carrie Buck didn't get to speak, and we only only have like a sentence of her words saying back at her one hearing, I'm going to rely on my team. Carrie Buck actually thought there were men out there who were fighting for her. There were not. Here, though, finally, we did hear from Britney Spears. And I think because of that, hopefully there'll be a different outcome than there was for Carrie Buck.
Yeah, Ria, I want to turn to you in a moment, but Adam, you're right. Britney Spears' celebrity has certainly elevated these issues in a way that they haven't before. And your book, Imbeciles, and the comments you just gave, tell us about this long history of sterilization, forced sterilization, particularly that women have been subject to. And I know that the ACLU, RBG has a history in challenging forced sterilization. If Ria, you can talk to us about some of that work, and also any initial thoughts you had about Britney Spears' testimony in June.
Sure, thanks, Alexis. I mean, to me, coming at this from a women's rights angle, I will admit I had not given much thought to this concept, the legal structure of conservatorship before Britney Spears' case became so public. And the first thing that it immediately reminded me, of course, was a parent-child relationship, because this idea that a person can sort of wholly give up their legal rights to another person is very much what it was like to be a child. And in fact, mentally disabled adults are often compared to children or described as childlike. Side note, we don't know whether Britney Spears identifies as a person with disability. So I did want to note that, of course, she's perceived to have a disability. And so in that sense, I don't know that it really matters, but we've yet to hear from her, I think, as to whether she identifies in that way. So I wanted to just put that out there at the beginning of our conversation. And of course, another family relationship that has often involved one person wholly giving up their legal rights to another person historically is marriage. Because married women, of course, did not retain legal rights. And because this is the Birnbaum Center, I have to mention an even older Supreme Court case, Bradwell versus Illinois, which is, of course, the case about whether women can be excluded from practicing law. And in that case, the Illinois Supreme Court essentially said, well, how can a married woman be a lawyer when she can't even make a binding contract? Right? And that was affirmed by the Supreme Court, the United States Supreme Court in 1848. So this is another legal framework like marriage that it allows a conservator, in this case, a man, Britney's father, to make decisions for the conservatee, here a woman. And the statistics do bear out that relationship. As you shared at the beginning, statistics about conservatorships are hard to come by, but in data that we cited in an ACLU amicus brief filed in Britney's case, approximately 2/3 of people in conservatorships are believed to be women, about 67%. We also looked at data in Los Angeles County and found that though Black people represent just under 10% of the population, Black people represent 23% of those in conservatorships. So we see very dramatic gender and race disparities in that context, which really is consistent with, as you say, this long history of forced sterilization, which has often been at the intersection of race and disability and gender and often poverty as well. We're very proud in the Women's Rights Project of work that our founder, Ruth Bader Ginsburg, did on this. And I think it's not as well remembered, perhaps, because it didn't result in a fancy Supreme Court argument, but certainly in the justice's own mind, I think this work was a very core part of the work that the Women's Rights Project did in the 1970s, and that she believed was within its core mission. In the same year that she had her first Supreme Court argument, she filed a case on behalf of Nile Cox, who was a woman who was subject to North Carolina's forced sterilization program. Truly horrific set of facts. A young woman who became pregnant at 18. Her mother then, who was receiving public assistance and had quite a few children, is told that either when your daughter gives birth, you can agree to have her sterilized, or we will cut you and your entire family off of public benefits. The mother obviously has no ability to say no in this situation, and she's told that the process is reversible. And so as the surgery approaches, you see Nile in her deposition testimony saying, are you sure? Are you sure this is reversible? And the doctor's saying, why do you keep asking questions? You don't have anything to worry about. Everything is fine. And just sort of being dismissed as a hysterical woman. And it's only many years later when she becomes engaged and she goes to see her obstetrician because she's hoping to have more children in that marriage that she learns that this procedure that was done to her many years earlier, in fact, was not reversible. Incredibly, this case gets litigated primarily on the question of whether she was too late to file suit because the statute of limitations had already run before she even learned she had been forcibly sterilized. Just another sort of barrier to people having their claims heard. And by the time that question was resolved, North Carolina had ended its forced sterilization problem. So the court never really got to the merits, which brings me back to something that Professor Cohen said earlier, which is this idea that these decisions the program was never found to be unconstitutional because the state ended it before the question could be answered, just as Buckley Bell has never been overruled. So we have this very disturbing legacy, and people responded to the Britney Spears situation saying, is this legal? And I think the answer is yes, in part because of those programs the decisions that have not been overruled and the programs that were never found to violate the Constitution.
Yeah, thank you for weaving together that history, which, as Adam pointed out as well, is repeating itself. What we see in all of these cases, and the example that you gave us from North Carolina, are these very private matters being elevated and shared with the public, and other people making decisions based on a person's essentially private medical health, all this kind of decision making that we're used to deciding in private. And I know Professor Harris wanted to jump in here to discuss some of the privacy issues that are at stake. Professor Harris.
Well, I was struck by, Adam, your comment about this is the first time we've kind of heard someone say very publicly, I want out of a conservatorship, and why, and some of the things that she's been subjected to. And part of that has to be part of the story. Disability historically has been deemed private. Information about disability has been equated with medical data or medical information. And in proceedings and legal institutions such as conservatorship, this is often a shield. It shields the sunlight, it blocks the sunlight, and we're not able to understand not only the number of people who are under conservatorship. We have a rough number, 1.3 million, and Ria's telling us about some of the data that they've been able to collect, but I suspect that it was difficult. It's no easy task. There's no reporting requirements. There is no regular oversight of this system. And so part of that is to take the step back and say, this is a phenomenon that is common with disability, is that it's deemed to be embarrassing. It's deemed to be something that is medical data. And so my work has really talked about how do we take a step back and say, look, this is not a private matter. The things that Britney was talking about, she talked very openly about her lithium. She talked about her therapies and the therapists. And so those very reasons are not enough to block the public from hearing what's going on in these proceedings. And the liberty interests are so high, it's so odd that these proceedings would be closed. And it's led to a lack of public education about exactly what these proceedings are. So I would encourage us as we move forward to think about and question when something is labeled private, particularly in the disability context.
If I could inject just one more thought, which is the idea of money, which I think we should really keep front of mind in all this, because when I think about what is really driving this case, why is Britney being put through this? This is a case about money and greed, as far as I can tell, about her father literally just wanting the tens and tens of millions of dollars that she's earned, putting her out on the road, even when she doesn't want to go, to earn more money. And then all of the lawyers who were at the trough, right, making so much money off of her. And what's interesting is in 1927, we had the idea already that reproduction was a fundamental right, and that reproduction was important. But look how it got trumped by this crazy idea of eugenics. The country got caught up in eugenics and said, well, it'd be nice if women could control their own bodies and if people could reproduce when they want to, but it really is so important to save the gene pool. Look at how now we also recognize reproductive rights are very important and and shouldn't be taken away except under the most extreme circumstances. But look at how in 2021, how money is so central to our culture, and how all these people have found financial reasons for stopping her from, doing what she wants to do, including reproducing. And look at how up until now, the court system is signed on with those people who want the money, not with the woman who wants her freedom.
Can I piggyback on that point, Adam? The point about money it's particularly apt in the Britney Spears situation because she's obviously quite wealthy, and the wealth, I think, feeds a lot of the decisions that those who are in charge of her care are making. I'm certainly, the fact that she has an IUD installed and her parent and her father will not let her take it out or become pregnant has a lot to do with, one, not having any other dependents who can make claims on her fortune, but also not having her incapacitated by pregnancy, which would make her unable to continue her Vegas residency, which is quite lucrative for her and for all of those who are financially dependent on her. All of that, I think, feeds into the narrative that has surrounded not only the eugenics movement, but the expansion of forced sterilization to communities of color under the guise of protecting scarce state resources. So as Ria noted, in the 1960s, when more women of color are admitted to public assistance, and they had not been initially eligible for public assistance under the terms of the Social Security Act when it was first enacted in the 1930s, but they're later admitted in the 1960s after incredible agitation by welfare rights workers. But when they are admitted, people begin to wonder, those in charge of the programs begin to wonder whether these additional people are going to be a drain on state resources, and sterilization is viewed as one way to limit the demands of those who are already on public assistance by limiting their ability to have future dependents who will also be dependent on public assistance. This is part of the logic that feeds family cap provisions that are only now being unraveled in states like California, but remain on the books in many other states throughout the country. So all of this is intertwined. It's all sort of interesting to think about it through the lens of Britney Spears, someone who is not on public assistance, who will likely never be on public assistance, but who, because of her ability to fund these legions of other people who are dependent on her, like, can show us how these issues are really salient and how they all feed this desire to control individual bodies.
Yeah, I just wanted to pick up on something else that Adam mentioned about sort of this idea that Britney's case is in tension with our modern notions of reproductive freedom. And I guess just sort of push back on that a little bit. I mean, I think part of what was so shocking about Britney's case is that here's somebody who wants to have and continue a pregnancy being denied that right. And we're typically think about reproductive freedom being curtailed in the context of people who seek not to become pregnant or who want to terminate a pregnancy. But in fact, there has long been this sort of dual control, the control over continuing a pregnancy or carrying a pregnancy to term, and the control over becoming pregnant and terminating a pregnancy. And, because I feel it's my duty to plug RBG, I have to say that, she had hoped that the first reproductive freedom case the Supreme Court would hear, or the first case involving pregnancy, was the case in which she represented Captain Susan Strzok. And I see Professor Murray nodding, because of course she knows the story of Susan Strzok, who was in the Air Force and became pregnant. And at that time, the Air Force did not allow pregnant people to serve. And so she was put to the choice to either terminate her pregnancy or lose her job. And that was the case that RBG had hoped would be sort of the beginning of this jurisprudence. Now, query whether everything would have been puppies and kittens if that had been the case and not Roe. But in fact, the Air Force mooted out the case by ending its policy and allowing Susan Strzok to continue to serve. And that meant, of course, that the case law has largely developed in the context of people who seek not to be pregnant or don't choose not to carry their pregnancies to term, which is a very different context. But I do think that's part of what was so jarring for many people about Britney's situation. Again, is this is somebody who wants to have a pregnancy.
So just to add on to what Ria just said, I'm like nerding out here. It's not just that the Air Force required pregnant women to terminate their pregnancies or lose their positions in the military. They actually paid for the abortion if servicewomen intended to do that. So when you think about that juxtaposed against the Hyde Amendment, where federal funds cannot be used for abortion, I mean, it's a completely jarring disjunction. And also to bring it back to Ruth Bader Ginsburg, part of the reason why she was, I think, quite interested in litigating Niall Cox's case is because she was trying to expand the notion of privacy that Roe versus Wade had really entrenched, to show that reproductive rights weren't simply about avoiding pregnancy, but actually being able to give birth and to raise a family in conditions of safety and security, if that's what you wanted to do.
Well, and I think it's also interesting in the disability rights context how the idea of modern sterilization looks differently too. So with respect to women with disabilities, it's often the case that young women with significant disabilities, their parents are told, well, if we actually sterilize your child or if we have a procedure done, this will give them more reproductive freedom and autonomy and agency. And so it is in your best interest to do this early, often before puberty. The other aspect in terms of the line of eugenics that we're seeing today, we're also seeing the issue of limited access to transplants and medically necessary treatment. And this is disproportionately, of course, it falls on the backs of people with disabilities, and within that group, people of color and other marginalized identities who also have disabilities. So it's important to kind of see that thread of what modern eugenics looks like. Yes, it does look like Britney Spears, but more often what doesn't get the attention is that it looks like the early sterilization or early treatment and removal of reproductive freedom for young people.
And what I'm hoping we can also address is within the context of a conservatorship or guardianship, the individual's right to independent sort of counsel. And so I'm seeing all the context of the right to counsel and counsel of choice, and particularly for folks who are indigent, which isn't Britney Spears' case. And I gather that she's now secured new counsel, but for someone who is indigent. And my understanding is in California, the court often appoints like a public defender who may not have the specialized training to advocate for somebody that's subject to a conservatorship. And I know other states are navigating this in different ways, but I wonder if anyone has comments on what is the independent sort of agency like for someone who wants to remove themselves, such as Ms. Spears does, from the conservatorship, from the guardianship relationship.
I think that was one of the most interesting things about Britney's statement is when she said, I didn't know I could petition the court to end this. And it just, as soon as she said it, it seemed so obvious. Like, why would she know that? Why would anyone know that? But it felt really shocking. And this is another place, I think, where her inability to choose her own counsel felt like we've normalized the idea that people who are indigent don't get to choose their own counsel. But we're shocked at the idea that someone who can afford to hire a lawyer of their choice might not be able to. And this is actually the issue in which the ACLU filed an amicus brief on behalf of 25 disability rights organizations, talking about the right to counsel includes the counsel of one's choice and everything that comes with it, which, by the way, includes ability to communicate with your counsel confidentially, which opens up a whole other can of worms when you think about the fact that Britney otherwise doesn't have a secure and private way to communicate necessarily with anyone. All of her communications could potentially be viewed by the conservator. And of course, confidentiality is such an important part of that relationship. And smaller things too that she's been deprived of, the ability to take the hair vitamins that she likes, coffee, to see friends, these small details that come out, and you think about it as ways of restricting someone's world until they're so confined that it doesn't occur to them that there's a way out.
But I think that's a product of the legal institution of conservatorship, and that combined with our lack of understanding of disability and how, if we disaggregate, it exists along a continuum, and legal capacity. The notion that because someone needs support in one area of their lives, that they're going to therefore need someone like a conservator to guide every decision that they make. That's, I think, the confusion around the right to counsel, because the notion is, well, she's under conservatorship, she can't enter into contracts, she can't retain her own lawyer, and she can't make that decision. That is making an assumption, a huge assumption, and it's not really following the law in terms of how it's supposed to be interpreted and applied.
Yeah, thank you for that framework. I know in advocating on behalf of people with intellectual disability, one of the most helpful things that I learned was that strengths exist with weaknesses. And so your client can do lots of things and may not be able to do some things, but that is the diversity of the way that certain intellectual disabilities or disabilities in general manifest and present. So that's a really helpful way of looking at this. Do you anticipate, and I want to open this up to everyone, changes in conservatorship laws and guardianship laws as a result, a byproduct of what we're all seeing with Britney Spears' case?
I think we saw just yesterday, maybe, or a day or two ago, there's been a proposal in the House. I think it was offered as a bipartisan proposal. I think Charlie Crist from Florida is the Democrat on the bill, but it's a bill that would effectively allow individuals who are under the care of a conservatorship or guardianship to petition the court to end that arrangement. So it's a good initial first step. And again, it has to get through the House. It would then have to get through the Senate in order to become a federal law that was then applicable to the states. But it's worth noting, it's not clear that it goes far enough to deal with many of the issues that conservatorships raise. I mean, for example, there isn't much in the bill that actually talks about how conservatorships or guardianships are actually constructed and who's selected and what the criteria for being selected is. Doesn't address this issue that has become more prominent since the Netflix movie I Care a Lot with Rosamund Pike came out this spring. But those sort of for-profit conservatorships where individuals are appointed by the court but actually draw a salary because of the work they do on behalf of the person under their conservatorship, none of that is addressed in this bill as well. So it's an initial first step, and it seems to be a response to the incredible media attention that's been created because of Britney Spears' case. But it probably doesn't go as far as it needs to really get at the root at what is animating many of the difficulties that Ms. Spears and others who are under conservatorships are experiencing.
A couple of thoughts. One is I have a good friend whose child has an orphan disease, so a disease that not that many people have. And when she went to lobby Congress, she said, everyone said to her, come back with a celebrity, right? Because Julia Roberts had just been there on behalf of a disease that a friend of hers child had, and they got a lot of funding. So I do think, as Professor Murray says, I think this could really change things just because Britney Spears has that kind of star power to focus us on an issue that NPR did a great thing about conservators a year or two ago, an hour on point, and it raised all these issues, but no one was focusing on them. But I also agree with Professor Murray that the law that was just the bill that was just presented doesn't go far enough, and the entrenched power of the conservator lobby is going to be so strong. George Bernard Shaw said that all professions are a conspiracy against the laity. And that's certainly true of the legal profession, right? I mean, there are so many people making money off of conservatorships. And like in New York City, we have surrogate judges who there are only 2 in each borough, and they get to appoint conservators for estates and for individuals, and the fees are so large, and in many cases some of those fees get kicked back to the organization, the political organization that then nominates the surrogates, and this goes on around the country. So there's so much money and so much power behind the status quo that I think it's going to be hard to make a lot of progress, but hopefully this is a galvanizing moment.
And if I could just jump in, I think the conversations, I agree with Professor Murray, I agree with you, Adam. I think that we need to use this moment, though, to take a step back. And so we need to take the step back and say, what is this legal institution? How is it designed? And do we need this type of institution? Just that very basic question. So the law reform has to begin from that moment and say, well, this institution that was created, gosh, dating back to certainly maybe even earlier than English common law, but the notion that we need assistance in making decisions, this concept, we all do. I start my conversation about conservatorship with my students by saying, think about a major decision in your life that we've all shared. Going to law school. Let's unpack. How many people did you talk to? What other steps did you take? You went to Google, you did this, you did all of these things. And by the end, we have this board filled with support, with the scaffolding that people use to make decisions. And so the notion that conservatorship is the only way because it's efficient, because it's perhaps the way that we've done it all along, that needs to be questioned. And so I really hope that these conversations don't start out assuming conservatorship is the right institution for what it's trying to do.
Yeah, thank you. I think a lot of these reforms are contemplating something that's less restrictive, something that is a little bit more nimble. And so there's maybe this shared decision-making framework that varies depending on how the nature of the disability presents. So I think that's a really important issue looking forward. Professor Murray?
It is worth thinking about the conservatorship and conservatee relationship is a status relationship in much the same way as Ria said, the parent-child relationship is a status relationship, the husband-wife relationship is a status relationship, the master-slave, employer-employee, they're all status relationships. And at some point in our history, I mean, there's this old saw, like, the progress of civilization is from status to contract, where all of these status relationships get renegotiated and reconsidered over time. In 2015, we saw a massive renegotiation of the status of marriage to include same-sex couples. Maybe this is part of that evolution. This is one of the stickier status relationships that have endured for some time, ward and state, conservator and conservatee. And what we're seeing now, perhaps because of Britney Spears, is an effort to sort of reconsider and begin renegotiating the boundaries and terms of that status relationship, making it less sticky than it has been in the past. So this may just be a part of what we have attributed to legal progress over time in a lot of these relationships.
Yeah, I just wanted to pick up on something else Professor Harris said. I loved your example about using supported decision making to decide, whether and where to attend law school. And we made a very similar analogy in our brief where we talked about the decision whether to have surgery, because I think when you think about the decision to whether or not to have a child, well, that's a really important decision. It's really important to get that right. But the reality is that as adults, we're allowed to make bad decisions. They are our own decisions. And for example, in considering whether to have surgery, you certainly would consult with the surgeon. But at the end of the day, it's up to the patient to decide whether or not that's the surgery that they want, even if the doctor might think, that's a bad choice or that's the wrong choice. And so this idea that somehow we need someone to make the right decisions is actually, very inconsistent with, notions of autonomy and agency that we historically have afforded to very few adults, and over time have expanded the number of people who get to enjoy that autonomy and agency.
And that concept is called in disability rights, the dignity of risk, which is incredibly poetic and beautiful, the right to make both good and bad choices and not have them taken away from you. And so that is a central core component of disability rights. And that's why Britney's story is deeply and intimately.
Great. So I have a ton more questions, but I see a few from attendees, so I'd like to get to some of them, and then we'll continue the conversation. So El Sarma asks about the gender narrative that's unique to Britney Spears' case. So in the past, we have seen other male celebrities grapple with their presenting disabilities, mental health conditions. And the questionnaire cites specifically Kanye West and Charlie Sheen, and yet their manifestations of their mental health conditions didn't result in some sort of conservatorship or guardianship. And so whether you want to stick to these three players that I've identified or speak more broadly about how the Britney's identity as a woman plays into all of this. And the questioner also relates Britney to Judy Garland and what happened to her towards the end of her life in celebrity.
I'm happy to go first. I'm curious to hear what others have to say. I mean, it's impossible to separate this relationship from gender and from the way that people of different genders relate to each other. So I shared at the outset the statistics about who's in a conservatorship, and I think rates of disability are roughly equivalent across men and women. Now, perhaps there's some edge because women as a group, tend to live longer, and elderly people are often subject to conservatorships, but I don't think that fully explains the really vast disparity that we're seeing. So we know that similar behavior and similar disabilities are being treated differently when they're displayed by women as compared to when they're displayed by men. And then once people are in conservatorships, this focus on reproduction and sterilization, again, is very, very targeted at women. So we've heard from advocates in the disability community who say, they've never seen men with disabilities sterilized. Now, it has happened, and certainly as part of the massive state eugenics programs we talked about, we know there were many men who were forcibly sterilized. So I don't think it's a zero. But it is true that women's reproductive decisions and women's ability to reproduce is sort of uniquely the target for this kind of intervention, and particularly when you do have this lopsided dynamic. Again, it's not just that it's a man and a woman, it's her father. So we're literally sort of reproducing the parent-child relationship that Britney Spears and her father had long ago, except now she's an adult.
And it really echoes Professor Murray's opening comments about disability being a social construct, and then that those that are subject to this relationship that's vulnerable to abuse tend to be those that are already marginalized through their social constructs of their identities, race, and gender to an extent. There's another question about the legal mechanism that was used initially that placed Ms. Spears into a conservatorship, and whether that was lawful. So that temporary hold that placed her in an involuntary mental health facility that then moved into a probate conservatorship And then the question ends with, do we think that the legal community, disability rights advocates need to help establish sort of higher standards, more stringent standards to initially place someone in a conservatorship? And then related to that, do we need to ease the legal standards to allow people to get out of a conservatorship or a guardianship?
Well, that's a multi-part question. That's great. If I can just jump in first and start the train. The conversation about the initial, what happened in 2008, part of it is we don't know. Part of it is we can't get access to these records. And that goes back to my point about publicity and privacy, how these proceedings are deemed so private that we don't get to see what actually transpired. That's an important part of Brittany's story. It's also an important part of every other person, the 1.3 million plus who are actually under conservatorship today across the country. The second is the question about legal standards. And I would say it's not just a question of how high we make it or how difficult we make it for someone to be under conservatorship. Conservatorship right now, as it is in most states, is seen as technically a last resort. It's overused, though. We know that that's the case. And so what we're talking about is not just law reform that needs to happen, but reform around social norms. How are we going to get people to understand the purpose of this system and how there are other legal mechanisms that we could use, informal and formal, before going to the nuclear option of conservatorship?
And Adam, was this any different? I mean, the law and the standards that we have today, it seems to echo so much what was occurring in the early 20th century with sort of this indefinite conservatorship relationship and indefinite status as being someone who wasn't capable, didn't have the capacity to make legal decisions for themselves.
Yeah, I mean, I mentioned before this idea of horrified deja vu, and that's true of the procedures as well, because when I was reading about what they did to Carrie Buck, her whole story began with a feeble-mindedness hearing where she was brought in before a panel that just decided based on really no evidence that she was feeble-minded. That was the first step to sending her to the Colony for Epileptics and Feeble-Minded, where she then becomes sterilized. I remember thinking, what a crazy procedure with no standards and no one's there to look out for her interests and all that. And, flash forward a century, and what happens to Britney Spears? It looks like something quite similar. And so I think that we have a way, we historians of looking back and saying, like we're standing from a point of vast progress and improvement. But here's an area of taking people's rights away and imprisoning them or preventing them from reproducing, where it's amazing how little progress we've made.
Mm-hmm. There have been a flurry of related questions about how one gets out of a conservatorship if their disability isn't static. And so you have sort of the changing status and nature of disability. And Professor Harris, I'm sort of looking towards you. I know it's hard on Zoom to see that I'm making eye contact with you, but how does one navigate these sort of status-like relationships, as Professor Murray defines them, when there is a changing nature and presentation of someone's disability and capacity?
Well, there should be, according to most states' laws, a regular process to revisit the need for the conservatorship. And there are court investigators who will speak with the conservatee and all of the parties involved. Now, that is on autopilot in many places because there's this, again, notion that disability is an on-off switch, and therefore once you turn the light on, you cannot turn it off. Similarly, the legal standard for restoration of rights, which is what the questions I think are asking about, the restoration of rights to get out from under a conservatorship, that legal standard in many states places the burden on the conservatee to show that they have the capacity and no longer need the conservatorship. That is a near impossible legal standard. It's like if you are in for example, a psychiatric institution and receiving psychiatric care, once you are admitted, any decision that you make that is counter to what norm says, right? So the norm of, what the doctor wants or thinks is a reasonable decision is going to be counted against you. So it's very, very difficult as a practical matter to get out from under a conservatorship once one has been instituted. That's why we really need to see conservatorship as a last resort and really take a look at those front end procedures as well.
I see we have more questions coming in on the relationship with counsel. Is the answer, particularly for folks who are indigent, because as I mentioned before, Britney Spears has now been able to hire a different lawyer, but for people who are indigent, what are the options to navigate and to secure someone who can advocate for you outside of the role of the actual conservator? So I don't know if the nomenclature is like a guardian ad litem or somebody independent of the person making the decisions. How do we go about improving that representation? What is the landscape out there for disability sort of advocate attorneys outside of the disability rights attorneys who are doing impact sort of litigation? I know Ria's colleagues who filed the brief. I don't know how much individual representation in these kind of matters exists, and what does that landscape look like?
I think a broader question, one that is as much about the legal profession and legal ethics as it is about disability rights. But so I just want to sort of maybe step back and make a couple of observations. One of the things that I think has been most pronounced about the treatment of disabled persons in the United States, as Jasmine said earlier, is it has been treated as a private matter, but not just sort of private, like we don't share that with other people, but we've actually sequestered these individuals from society more generally. And Carrie Buck is, a terrific example of that. She's actually incarcerated in a colony for people who have been deemed disabled in some capacity. So there is a way in which the inability to integrate the disabled into society also contributes to this veneer of privacy that in turn fuels and makes it possible for this kind of abuse and exploitation to happen. So I think in thinking about what needs to happen in the legal profession, I think we also need to think about, as lawyers, what are we doing about the landscape on which all of this is playing out and how that is changing? Like, maybe we should think about better integration of our society in all facets. I mean, we've had lots of discussions about race and inequality this year. Many of the individuals who have been deemed disabled are also people of color. Like disability needs to be a part of that conversation as well. And thinking about the landscape in which all of us inhabit the society and traffic the society is, I think, really important, because the only way you can sort of understand, I think, what is happening to these people, understand their humanity, is when we either we know that intrinsically, and I hope we do, but it is often easier to see that common humanity more easily if these are people we actually know and work with and see on a day-to-day basis. This is what people have said for years about racial integration, about thinking about sexual orientation in our society. And I think this is true. Like, one of the reasons why we are perhaps more tolerant of the exploitation of disabled persons is because we don't live in a society where it is easy to interact with them.
And these are exactly the themes that I know Professor Harris just writes about generally, but just in the more immediate. But your article, Reckoning with Race and Disability, the way that we think about people with disability in this country, there's a heightened sense of awareness, heightened sense of consciousness, which obviously Britney Spears is a big part of. But it's changing the way that we think about now the legal standards for people in conservatorships. It's changing the way that we think about accommodations outside of the ADA, which of course was a major push in the 1970s. But Professor Harris, I invite you to weigh in on that.
I think Professor Murray is exactly right on this. The aspect of this association of disability with privacy initially was done as a way to keep disabled people out of the public eye. You had the ugly laws that date back, that were on the books, by the way, in Chicago, for example, until the 1970s, where it said, if you are ugly, disfigured, you are not to be in public, you can be fined. And if you cannot pay that fine, you can be imprisoned. Now, was it actually enforced? No, but it's still on the books and it is telling. And so this perception, at least initially, of let's keep people with disabilities out of society. And then now it's swung the other way, where it's let's protect people with disabilities from the broader society, from the stigma of disability. And so we need to be more aware and cognizant and thoughtful about that pendulum and make sure that we're striking the right balance, because then we're going to wind up, if we don't, we're going to wind up right back where we are with respect to Britney Spears. I want to say one more thing, which is this notion of our understanding of disability. Part of that, I've argued in some of my prior work, comes from a lack of really knowing that disability, what disability looks like in society, right? And so when we associate disability with the quintessential wheelchair icon that's on bathrooms and in parking spots, but really disability is way more complicated. There are disabilities that are more or less apparent. And so the majority of people with disabilities in this country, which, by the way, the last report is 61 million adults with disabilities in the United States, a majority of those have less visible disabilities. And so part of the conversation that my work is trying to promote is what happens when that group the people with less apparent disabilities, they come out, so to speak, using the language from LGBT and gay rights movement. What does it look like then? Will we have a more nuanced understanding? Will we be less likely to segregate? And are we going to get to the place where Professor Murray says, where we do have this integration in the way that it has worked in other social movements? So I do think that that's an important conversation that needs to be had.
I'm so glad you mentioned the 61 million, Professor Harris, because I was thinking very much the same thing about people with hidden disabilities and this notion that we don't know people who are disabled. That 61 million people equates to 1 in 4 American adults. So the reality is we do, much in the same way we all know people who are LGBT, or for that matter, we know people who are transgender. We may not know they identify as transgender, but we certainly know them and they're in our lives. And it reminded me of sort of the famous story about Justice Powell, when the court was deciding Bowers v. Hardwick, saying, I don't know any gay people. And of course, one of his 4 law clerks that very term was gay and just not out to the justice himself. And so what would happen if people with disabilities were able to safely identify in that way and to change our understanding of what it means to be disabled, much in the way we've begun to change our understanding of what it means to be LGBT.
Thank you. You said that much more elegantly than I did. Thank you.
Okay.
Just to hammer home the point, if I can, 1 in 4, Rhea says, right? 1 in 4. So here we are, we've got 5. So I identify as a woman with a disability. It's less visible, but here you go, right? And it's important to have these conversations. It's important to have this discussion of representation wherever we go. And so I wanted to share that because I do think it matters. Representation does matter.
Indeed, thank you. We have a question about Jamie Spears, the person that the court has instituted as Ms. Spears' conservator. And the question has to do with whether or not he collects a salary, given his role as a conservator. And then if there are any protections in place that make sure that whoever is the conservator is making decisions based on the conservatee's best interest, if that's the standard, rather than maybe their own financial gains. And of course, this is, again, is a unique question, given the fact that Britney Spears does have, has amassed, I think her last net worth was calculated about 60 million, 60. And so what does that look like in terms of this best interest standard? Is that the standard that would protect against Jamie taking all her money?
Well, the standard should be not necessarily best interest, interest, right? Because that's the sort of paternalistic form of the system itself, but expressed interest. And so to the extent possible, if that individual can say, if they're under conservatorship, I want X, or this is the decision I would make, or my considerations, here's how I would want the decision to be made. Becomes more difficult if somebody, let's say, has a non-normative form of communication, but not impossible. Everyone has a way of communicating. It's just a question of figuring out what those wishes would be. It might be more difficult. So I think the legal standard needs to really be in line with the express interest. And it varies by state, as you said, Professor Hoag. It's just, some states are express interest, others are very clear about best interest. And this is why we need this sort of overall look at this really complicated hidden system.
Yeah, it does sound like there's only so much that Congress can do to change the conservatorship laws, because this is very much a local state issue. We have just a few moments left, so I want to invite any sort of last parting thoughts. I know there was so much that we could cover. Our early conversations about where this conversation could go were all over the place, but I know I'm grateful for this rich, robust conversation. And I know it is recorded. I know there are folks at the ACLU that want to tune in later, and hopefully we've got some students that have the ability to tune in later as well. So any parting thoughts, what we can expect next from Ms. Spears or the changing legal landscape of conservatorships?
That is a really tough prompt, and I noticed nobody wants to jump in. It's hard to sum up this whole conversation, but I did want to just briefly mention reparations for forced sterilization, because it's something that didn't come up, and it feels very much of a piece with the conversation we're having as a nation about reparations for chattel slavery. So far, only 3 states have really begun this process of paying reparations. And of course, because so many of these programs ran from roughly the 1920s to the 1970s, many of the people who were forcibly sterilized, are no longer with us to actually receive compensation from these systems. So I just wanted to name that. Obviously, in the context of Britney Spears, as so many aspects of her case sort of turn the typical case upside down. Here is someone with tremendous financial resources, but typically people who are targeted for this kind of reproductive control are actually the people with the fewest resources. And it really is important to interrogate what we can do to compensate people for those harms.
Yeah, I've been really struck by how varied the media reporting has been, and not necessarily even directly on Britney's case, but all of the related implications, and especially in California, I think where you're mentioning that the reparations are being awarded to people that were forcibly sterilized during this long reign of eugenics that Adam opened us up with. I just want to, take a moment where everyone's still on the webinar to thank each of you for bringing your expertise and just all the knowledge that you have in this area. So Adam, Professor Murray, Ria, Professor Harris, thank you so much on behalf of NYU Law, the Birnbaum Women's Program, LACA, and also the Law Alumni Association at NYU. Thank you so much.
Thank you, everyone. I'm echoing Professor Hoag's thanks to all of the panelists and all of the attendees today for joining in and helping make this such a wonderful conversation. So thank you again to everyone for joining us. We hope you'll join us for our upcoming programming. We have some book talks coming up on August 12th and October 7th. We also have a panel coming up on September 14th. That will be talking about beyond diversifying your board, so corporate implications. And then very exciting, our fall symposium will be coming up on September 24th, when we'll be highlighting the Marshall Plan for Moms and what would it mean for America to put care first. So thank you all again for joining us, and we look forward to seeing you again soon. Thanks. Bye.